Well, I'm going to start straight away on this because it's late. Well, late for me. So I'm apologise. There won't be any reading of my frog story. But Sean Rare's Long Island audit has had a bit of success. And I hope that I'm regarded as being fairly fair as opposed to having sides. And I think it's important to show what's actually happening in the auditing community. And so I have no shame in bringing you, I'm a bit loud, aren't I? In bringing you this. So let's get in it. As you may be aware, Sean Paul Reyes basically engineered his own arrest in a police precinct and then filed a lawsuit. And this is what we are going to be looking at. There's been a judge's order today regarding an injunction. I haven't read it all myself, so some of it will be new to me. Somehow I've managed to lose my window with the chat on. So there we go. Sorry, I'm just organising myself. So plaintiff Sean Paul Reyes. I will go through it because it's been some time since I did the original claim. I think I know I touched on it when Frauditors Exposed managed to put himself on this docket. So Reyes brings this action against defendant City of New York, alleging that the policy of the New York Police Department that prohibits recording in publicly accessible areas of New York Police Department precincts violates the First Amendment, the New York State Right to Record Act, New York Civil Rights Law, the New York City Right to Record Act, New York City Admin Code, and the Citywide Administrative Procedure Act, New York City Charter. That's quite a lot. Currently, before the court is plaintiff's motion for a preliminary injunction seeking to 1. Prohibit the NYPD from enforcing the policy set forth in NYPD Patrol Guide Procedure and that number, and NYPD Administrative Guide Procedure, that number. And 2. Require the NYPD to remove the signs in NYPD precincts setting forth the procedure. For the reasons set forth below, plaintiff's motion for a preliminary injunction is granted. Findings of fact. The NYPD has codified the procedure which authorises officers to arrest people who record inside the lobbies of police precincts in both its patrol guide and its administrative guide. Specifically in June 2018, the NYPD issued procedure number 203-29 in the NYPD patrol guide titled When a Member of the Service Encounters an Individual Observing, Photographing and or Recording Police Activity. And that states members of the public are not allowed to photograph or record police activity within department facilities. Members of the service may order any member of the public who is photographing or recording within department facilities to stop such activity. If such person refuses to stop, then they should be ordered to leave the premises. If such person refuses to leave the premises, members of the service may take proper enforcement action under the trespass statutes. The same language is contained in the administrative guide issued in June 2021. Plaintiff's motion has been granted, but we need to, I think, see the reasons why it was granted. And as I say, I haven't read it myself yet, but I'm expecting to see 1 or 2 cookies in here. So, the July 2020 bulletin from NYPD Legal Bureau notes that the patrol guide prohibits recording in NYPD facilities and further states when an individual is observed recording inside a department facility such as a precinct station house in any manner, an officer should immediately order the person to stop recording. If the person refuses to stop recording, the officer should order the person to leave the premises. If the person does not stop recording and does not leave the premises, enforcement for trespass is appropriate. Citation. Plaintiff Reyes is an independent journalist who reports. That's preamble. I'm not going to bother you wasting your time with that. I don't know if that's strictly correct, that he began because he's seen a lot of police misconduct over the years. We've got to remember the guy's a felon. And I think he probably did it for money. Reyes hopes to draw attention to police abuse through his journalism. On April 4, 2023, Reyes went to NYPD 61st Precinct. He had received a tip that NYPD was arresting people for filming in the precinct lobby. Reyes went to the 61st Precinct in order to file a complaint, investigate the situation, and report back to his viewers. Reyes, before entering the 61st Precinct, Reyes began recording a video. About 6 minutes after Reyes began recording, Sergeant Tazares Korshimet entered the precinct lobby from the non-public area of the precinct and informed Reyes that he could not record in the precinct, pointing Reyes to a sign that stated, "Members of the public are prohibited from audio-video recording or photography inside this facility." Reyes asked for Sergeant Korshimet's name and badge number. Sergeant Korshimet provided this information while directing Reyes towards the doors leading from the precinct lobby to the outside, stating again that Reyes could not record in the precinct. The sergeant then walked back into the non-public area of the precinct and Reyes continued to record. Shortly thereafter, the sergeant re-emerged into the precinct lobby along with Officer Giovanni Cucuzza. Officer Cucuzza told Reyes that he could not record in the precinct lobby and had to leave. The sergeant and Officer Cucuzza told Reyes multiple times that he was not allowed to record, that he would be arrested if he did not stop recording. Reyes did not stop recording and was subsequently arrested. Reyes was charged with violating New York Penal Law 104.05 and issued a desk appearance ticket. The Kings County District Attorney's Office declined to prosecute the arrest. 2 months later, on June 1, 2023, Reyes attempted to record at the NYPD 75th Precinct and was again arrested. He was charged with trespass. Different one. 140.05 this time. Criminal trespass in the third degree, New York Penal Code 140.10a, and obstructing governmental administration. The next hearing in the prosecution for the June 2023 arrest is in November 2023. Penal? I said penal. Yeah, I did say penal. How should I say that? Reyes would like to continue his investigations into the NYPD. He has stated that people want him to help them file complaints and record the interactions and subsequently post the video on his social media channels. He also likes making money from it. Reyes claims that he is not able to do so because he will be arrested again. On July 24, 2023, Reyes filed his complaint. Reyes alleges that the procedure by prohibiting recording in the lobbies of police precincts violates the First Amendment, the New York State Right to Record Act, the New York City Right to Record Act. Reyes further alleges that the procedure qualifies as a rule pursuant to the Citywide Administrative Procedure Act and that the NYPD did not undergo the required rulemaking process, making the procedure null and void. On July 25, 2023, Reyes moved for a preliminary injunction to 1. Prohibit the NYPD from enforcing the procedure and 2. Require the NYPD to remove the signs in precincts setting forth the procedure. On September 28, 2023, this court held an evidentiary hearing and oral argument on plaintiff's motion for a preliminary injunction. Conclusions of law. The court first considers the parties' arguments regarding whether the court must abstain from deciding the matter pursuant to Younger v. Harris. I've decided I'm not going to go through this part. I'll just scroll through. We've dealt with the Younger abstention, in other cases. So that's where the civil process can be stayed, awaiting the outcome of a criminal trial. Obviously, his criminal trial is still outstanding, but the judge has decided in this case that granting the injunction will not affect the criminal case. So there, we'll start there. Because the court finds that the requested relief would not interfere with the King's County prosecution, the court need not consider the additional factors of whether there is an ongoing state judicial proceeding that implicates important state interests and provides an adequate opportunity to raise federal challenges. Similarly, the court need not evaluate plaintiff's argument that the instant matter involves a series of repeated prosecutions to which plaintiff will be subjected, as such that there is an exception to Younger abstention. That's something that obviously Chile has failed with. 2. Plaintiff meets the standard for a preliminary injunction. A. Preliminary injunction standard. Preliminary injunctive relief is an extraordinary and drastic remedy, one that should not be granted unless the movement, by a clear showing, carries the burden of persuasion. And the citation. To obtain preliminary injunctive relief, the movement must show that 1. The movement is likely to succeed on the merits. 2. The movement is likely to suffer irreparable harm if in the absence of preliminary relief. And 3. The balance of equities tips in movement's favour, and an injunction is in the public interest. Citation. Whereas here the government is a party to the suit, the final two factors merge. Citation. When a preliminary injunction will affect government actions taken in the public interest pursuant to a statute or regulatory scheme, the moving party must demonstrate 1. Irreparable harm absent injunctive relief, 2. A likelihood of success on the merits, and 3. Public interest weighing in favour of granting the injunction. Citation. The typical preliminary injunction is prohibitory and generally seeks only to maintain the status quo pending a trial on the merits. Citation. A mandatory injunction, in contrast, is said to alter the status quo by commanding some positive act. What does it all mean? For those that are joining us, Sean Reyes has got an injunction so that he now has a right to film in police precincts at the moment. But we're going to see the reasons why. Where the movement seeks a mandatory preliminary injunction as opposed to a prohibitory preliminary injunction to maintain the status quo, the movement must also 1. Make a strong showing of irreparable harm, and 2. Demonstrate a clear or substantial likelihood of success on the merits. Citation. To warrant a preliminary injunction, plaintiffs need not show that there is a likelihood of success on the merits of all their claims for relief. Rather, plaintiffs must show a likelihood of success on the merits of at least one of their claims. B. Plaintiff has demonstrated a likelihood of success on the merits of the right to record claims. The court will now turn to plaintiff's likelihood of success on the merits under the First Amendment, as well as under New York State and New York City Right to Record Acts. For the reasons stated below, the court declines to consider plaintiff's Citywide Administrative Procedure Act claim. First Amendment analysis. Plaintiff brings two claims under 42 U.S.C. 1983 alleging violations of the First Amendment. First, plaintiff argues that the procedure deprives individuals of their First Amendment right to record NYPD officers in publicly accessible areas of NYPD facilities to state a claim for relief in an action brought under Section 1983. Plaintiff must establish that they were deprived of a right secured by the Constitution or laws of the United States and that the alleged deprivation was committed under colour of state law. Citation. Second, plaintiff alleges First Amendment retaliation. To state a claim for First Amendment retaliation, a plaintiff must allege 1. That the speech or conduct at issue was protected, 2. That the defendant took adverse action against the plaintiff, and 3. That there was a causal connection between the protected speech and the adverse action. Citation. Where the plaintiff is likely to succeed on the merits of his First Amendment claims, thus hinges on whether he was deprived of a right secured by the Constitution. The court first finds that recording police performing their official duties in public is protected under the First Amendment. Although the Second Circuit has not yet weighed in on whether the recording the police is protected First Amendment activity, other circuits have uniformly recognised a First Amendment right to record the police performing their duties in public. And there are various cases mentioned here, cited. There are a couple. For all of those that say auditors haven't achieved anything, we've got Turner v. Driver there, case law, and you've got Irizeri, I can't say his name, v. Yahya, who's Eric Brandt's mate. Someone type in chat. I've totally lost it. I've totally lost what his channel is. Someone will type it in chat. Isri's channel. Certain district courts in this circuit have likewise held that First Amendment protects the right to record police in public spaces. Citations. For substantially the same reasons set forth in those opinions, this court agrees. Moreover, the city does not contest the right to record police is protected by the First Amendment. And so there was a question, does the city dispute at all that there's a First Amendment right to record police activity? And they answered no. And in the patrol guide, it says individuals have a right to lawfully observe and or record police activity in public places, such as streets, sidewalks and parks, as well as private property in which the individual has a legal right to be present, such as building lobbies, workplaces or an individual's own property. Liberty Freak, thank you, Farlap Moves. I do apologise for my brain fart. NYPD, hang on, there's another citation. Civilians have a constitutional right, as well as express rights under state and local law, to observe and record police officers carrying out their duties. A. Public forum doctrine. Although the right to record police conducting official duties in public places is a constitutional right, nothing in the Constitution requires the government freely to grant access to all who wish to exercise their right to free speech on every type of government property without regard to the nature of the property or to the disruption that may be caused by the speaker's activities. Citation. Under the prevailing constitutional framework, speech restrictions imposed by the government on the government's property are subject to a forum-based analysis. Citation. Fora for expression are classified into 4 categories which fall along a spectrum extending from those deserving the greatest constitutional protection to those deserving the least constitutional protection. 1. The traditional public forum, 2. The designated public forum, 3. The limited public forum, and 4. The non-public forum. Citation. The first category of public property, traditional public fora, are places such as streets and parks which have immemorially been held in trust for the use of the public and time out of mind have been used for purposes of assembly, communicating thoughts between citizens and discussing public questions. Citation. A principal purpose of traditional public fora is the free exchange of ideas. Citation. In traditional public fora, content-based restrictions on speech are subject to strict scrutiny, and the government must show that such a restriction is necessary to serve a compelling state interest and is narrowly tailored to achieve that interest. Citation. Content-neutral time, place and manner restrictions must be narrowly tailored to serve a significant government interest and leave ample alternative channels of communication. The second category is the designated public forum, which the state has opened for use by the public as a place for expressive activity. Citation. A public forum may be created by government designation of a place or channel of communication for use by the public at large, for assembly and speech, for use by certain speakers, or for the discussion of certain subjects. The government creates a designated public forum by intentionally opening a non-traditional public forum for public discourse. Citation. And the government may choose to close a designated public forum. Regulation of designated public fora is subject to the same limitations as that governing a traditional public forum. Be interesting to see, for those that you are still with me, which is a few, be interesting to see if we think he's going to win or lose on the First Amendment grounds. Because I don't know. I haven't got that far when I read it. So, the limited public forum is a subset of the designated public forum. It exists where the government opens a non-public forum but limits the expressive activity to certain kinds of speakers or to the discussion of certain subjects. Citation. Restrictions on speech not within the type of expression allowed in a limited public forum must only be reasonable and viewpoint neutral. Strict scrutiny is accorded only to restrictions on speech that falls within the designated category for which the forum has been opened. Finally, a non-public forum is public property that the government has not opened for expressive activity by members of the public. The government may reserve such a forum for its intended purposes, communicative or otherwise, as long as the regulation on speech is reasonable and not an effort to suppress expression merely because public officials oppose the speaker's view. B. Forum analysis. So we're getting there. I don't know what the answer is going to be here. In determining the type of forum, courts examine the forum's physical characteristics and the context of the property's use, including its location and purpose. Citation. Courts additionally consider the government's intent in constructing the space and its need for controlling expressive activity on the property as evidenced by its policies or regulations. Citation. Courts have looked to the policy and practice of the government to ascertain whether it intended to designate a place not traditionally open to assembly and debate as a public forum, as well as to the nature of the property and its compatibility with expressive activity. Finally, courts consider whether the property in question is part of a class of property which by history or tradition has been open and used for expressive activity. Citation. The fact that members of the public are permitted freely to visit a forum does not abrogate its non-public status if the visitors are not permitted to express themselves freely in that forum. Citation. Plaintiff, Jean-Paul Reyes, argues that a police precinct lobby is a designated public forum. Defendants argue that a police precinct lobby is a limited public forum. Neither party argues that the lobby is a non-public forum. The court looks first at how a police precinct lobby is used. Police precinct lobbies are areas generally used by members of the public to report crimes, that should be, I think, and obtain information from law enforcement. The lobbies are open to the street or to a small vestibule that opens to the street and are accessible to the public 24 hours per day. Typically present in the lobby of a police precinct may be civilians who are victims of crimes such as domestic violence or robbery. These individuals may be at the precinct in order to report a crime, retrieve a report they have previously made, or talk to a member of the detective unit. There may also be confidential informants or those who the NYPD is trying to sign up as confidential informants. Members of the public can also use the lobby to obtain a complaint form alleging officer misconduct, as plaintiff contends he was doing here. Second, the court looks to the government's intent for the forum, as evidenced by the policy and practice of the government. Citation. Defendant argues that the forum's purpose is to ensure the public's safety. The city has shown an intent to ensure that victims of crimes receive emergency social and medical services as soon as possible and enjoy a freedom from intimidation, threats or harassment. Citation. The NYPD Legal Bureau Bulletin, in stating the reasoning for the procedure, lays out the government's intent for the forum. Due to the sensitive nature of what occurs inside police station houses, law enforcement agencies can limit expressive activities within the confines of a station house in order to uphold the sanctity of investigations, protect protect witnesses, and allow officers to perform essential functions without interference. There is no evidence that the government intended to open up police precinct lobbies for expressive activities, like peaceful protesting and leafleting, beyond being open to members of the public seeking assistance from the police, nor is there evidence that these lobbies have been historically used for unrestricted expressive activities. Indeed, those activities would be at odds with the purpose of a police precinct lobby, a space for individuals to seek assistance from law enforcement. Applying the preceding analysis to the present case, a police precinct lobby is not a designated forum that the state has opened for use by the public as a place for expressive activities. Courts will not find that a public forum has been created in the face of clear evidence of a contrary intent, nor will courts infer that the government intended to create a public forum when the nature of the property is inconsistent with expressive activity. Citation. This finding is consistent with Second Circuit decisions finding public meetings at City Hall, waiting rooms at a city agency, school gyms and school newspapers to be limited or non-public fora. Citation. Is that... I need to think of my non-public forum analysis. Sorry. That analysed Common Council public meetings held at City Hall as limited public fora. Another one finding that waiting rooms at the job centre operated by the Human Resources Administration of New York City were not traditional or public designated fora, as the government evidenced its intent to render the waiting rooms non-public by enforcing a written policy reserving them for official business or for activities specifically authorised. Another citation holding that the school gym during basketball games was a limited public forum, as the invitation to parents and spectators to attend such games did not constitute an invitation to anyone to disrupt the game with speeches about views on school policy or political issues. Another one finding school newspapers to be limited public fora because, among other reasons, the school did not invite all types of expressive activity in the newspaper. Plaintiff argues that even if a police precinct were a limited public forum dedicated to discussion of public safety, plaintiffs reporting on police activity is squarely within that dedication, which would require the government's restrictions on plaintiffs' First Amendment activities serve a compelling interest and be narrowly tailored to meet that interest. However, in limited public fora, government entities are permitted to restrict the form or manner of speech offered by members of the public, even if such speech addresses the topic or agenda of that forum. Restrictions on the form or manner of speech need only be reasonable and viewpoint neutral. Prohibiting recording in police precinct lobbies is a limitation on the form or manner of speech. As such, the court will assess whether the procedure is reasonable and viewpoint neutral. Sorry, I thought we were going to come to an answer there, but we haven't got to the answer yet. On the First Amendment grounds, remember, we know he's got his injunction. C, reasonableness and viewpoint neutrality. The NYPD procedure will be upheld as long as the policy is viewpoint neutral and reasonable in relation to the forum's purpose. Citations. A restriction will be reasonable if it is wholly consistent with the government's legitimate interest in preserving the property for use to which it is lawfully dedicated. Citation. Such a restriction need not be the most reasonable or the only reasonable limitation. Defendant avers that the purpose of the procedure is privacy, safety and security. And this is from his memorandum. Permitting citizens to record in the police precinct vestibules creates safety, privacy and security concerns for members of service and the public. Indeed, there is a legitimate state interest in protecting the safety of citizens. At police precincts, victims of crimes report crimes or otherwise utilise the services of the NYPD, as do witnesses and confidential informants. Enabling the public to record these victims when entering the precincts would compromise the safety of those victims and could have a chilling effect on crime reporting. When individuals come in to report domestic violence or sexual assault, they will come in through the lobby and speak to an officer about what occurred. Pursuant to the patrol guide, officers turn off their body cameras for conversations regarding these types of incidents. Victims and witnesses of crimes may be less willing to go to a precinct to make a report if they know that they may be captured on camera doing so. Victims and witnesses also may not want to have their identities memorialised on camera, especially when that recording may be posted online for anyone to access. Individuals may not want the audio of their conversations to be recorded, as they may be sharing personal and intimate details about a traumatic moment they experienced. According to the NYPD, recording confidential informants may also have a chilling effect, as informants may be exposed to reprisals and the investigation in which the confidential informants are participating in may be compromised. As to the privacy concerns about recording, plaintiff points out that crime victims and witnesses have a number of ways to contact the police other than waiting in a public lobby. Members of the public are able to call precinct 911 or Crime Stoppers. The Special Victims Unit additionally redesigned its facilities so that those reporting sexual assault do not have to wait in precincts. If a person wants to report a crime with sensitive details, a precinct can make arrangements for them to do so privately. Crime victims and witnesses are accordingly able to contact the police in such a way as to ensure that they avoid being captured on a recording being made in the precinct lobby. Plaintiff further notes that it is not illegal to record on the sidewalk outside of a precinct. A person would be able to record victims of crime and confidential informants who are going in and out of a precinct, even if that person is not able to record in a precinct lobby. However, these recordings would not capture the conversations that these individuals are having when speaking to police inside the precinct lobby. Defendant additionally argues that the safety and security of officers in the precincts could be compromised if recording in lobbies were allowed. Not all NYPD precinct lobbies are configured in the same layout. In certain precincts, there is a wall separating the lobby from the rest of the precinct, but the wall stops about 10 feet high and is open above. In a configuration such as that, someone who is recording video will be able to record a significant amount of the precinct, including potentially prisoners who are in handcuffs or are being transported around the inner parts of the precinct. In some precincts, the public may be able to observe what is called the muster room. In muster rooms, sensitive information may be exchanged, such as the location of where a search warrant is to be executed or information regarding persons of interest. In most precincts, the public is also able to view the area where firearms are secured when a police officer is walking into an area where they cannot bring their firearm. Plaintiff responds that a plaintiff who is in the public area not recording could see all these things. However, being able to view or listen to these occurrences is different from being able to record them and post them to the internet for anyone to be able to view. Recording creates a permanent image. Sometimes someone can record in high resolution and create images that are not visible to the naked eye. Audio may pick up on conversations or noises that a person's ear cannot hear. Editing or manipulating the video after it is taken may present additional concerns. During the video, Reyes zoomed in, stupid idiot, on various people and objects, underscoring some of the city's concerns about allowing recording inside police precinct lobbies. Reyes confirmed that he zoomed in because he wanted a closer look on people or information inside the precinct. Stupid idiot. A couple of minutes into the video, Reyes zoomed in on a police officer standing in the doorway in front of a restricted area. Later, Reyes zoomed into the restricted area behind the desk where civilians are able to speak with officers. The video recording also captures the hallway of a restricted area. Defendant's witness stated that there did not appear to be sensitive information down that particular corridor, but there can sometimes be posters containing sensitive information that is not generally meant for the public. At one point, the video recording captures the sergeant entering a security code into a keypad. The video also captures the NYPD security cameras in the lobby, which defendant's witness has suggested creates a concern that those cameras could be documented and memorialised. The city has presented privacy, safety and security interests that are implicated by video recording in police precinct lobbies. Although plaintiff has presented countervailing considerations for each concern raised, based on the evidence currently presented at this juncture, plaintiff has not sufficiently refuted the city's claim that prohibiting recording in police precinct lobbies is a reasonable restriction. A reasonable limitation will be struck down if it is in reality a facade for viewpoint-based discrimination. Citation. Plaintiff has not claimed that the procedure restricting recording in precincts discriminates on the basis of viewpoint, and the court sees no such way that it does. Accordingly, plaintiff has not shown a substantial likelihood of success on the merits with regards to its challenge that the procedure violates the First Amendment. Right, I'm just going to take a little rest there. So we're 21 pages into a 27-page document, which at the outset we knew Reyes had got his injunction. So he's got his injunction, but he hasn't got his injunction on First Amendment grounds. And if anything, he has proven... Hang on, I shouldn't really go to chat. I'm sorry, because that will delay me getting through this. But I do need to take a quick break from reading. We will see why he's won, but as I say, it's why I don't like sides. It's why I don't like I don't particularly like the term frauditors unless they're really, defrauding the public, which obviously some of the First Amendment auditors are frauds in their own right, but I don't think I don't like it as a term for all people who film police. Because in doing so, Reyes has actually, possibly by bringing this suit, he may well have been able to get the message out to some of the idiots with cameras that they can't record police exactly where they want to all of the time. Right, on to number 2, state and city right to record laws, supplemental jurisdiction. So he's obviously won on something in here because he hasn't won in the first 21 pages. The court is aware that the subsequent claims are not federal ones. Having found that plaintiff has not demonstrated a substantial likelihood of success on the merits of his federal claims, there is a question of whether analysing plaintiff's state and city law claims are appropriate here. The court finds that it's still appropriate to analyse these claims. Yeah, I mean, he gets close to my definition because he rakes the money in and he says he's not got money, and yeah. I much prefer the term First Amendment auditors and cop watchers and antagonisers. I'm sorry. That's me. Sorry. The court finds that it's still appropriate to analyse these claims. First, 28 U.S.C. 1367 does not preclude the court from doing so. The court has not and could not without notice dismiss plaintiff's First Amendment claim sua sponte. 28 U.S.C. 1367 does not require a different result either. This provision states that the court may decline to exercise supplemental jurisdiction over a claim that raises a novel or complex issue of state law. The instance in which courts have declined to exercise supplemental jurisdiction over novel claims do not apply to the instant matter. Courts in this circuit have generally declined to exercise supplemental jurisdiction over state claims either. When 1. The state law claim presented not only a novel question of interpretation of a state statute, but one that involves the state's interest in the administration of its government. Or 2. The state law claim was both novel and complex. Citation. Here, the State and City Right to Record Acts do not involve the state's interest in the administration of its government, nor do they present complex issues. The statutory language as applied to this circumstance is clear and unambiguous. Although there are only a handful of cases analysing the State Right to Record Act, it does not mean that the state law is unsettled or that there is a novel issue for the court to decide. As described below, the plain language of the statute, combined with the city's failure to present any meaningful defence to these claims, mandate the result here. Right to Record Acts. The New York State Right to Record Act, enacted on July 14, 2020, provides that a person not under arrest or in the custody of a law enforcement official has the right to record law enforcement activity and to maintain custody and control of that recording and of any property or instruments used by that person to record law enforcement activities. Persons are barred from recording if they engage in actions that physically interfere with law enforcement activity or otherwise constitute a crime defined in the penal law involving obstructing governmental administration. The NYSRTRIA further creates a private right of action. Similarly, the New York City Right to Record Act, together with the New York State Right to Record Acts, enacted on August 14, 2020, states that a person may record police activities and maintain custody and control of such recording and of any property or instruments used in such recording. The law further provides that nothing in this chapter shall be construed to permit a person to engage in actions that physically interfere with an official and lawful police function, or to prevent the seizure of any property or instruments used in a recording of police activities where the seizure is otherwise authorised by law, or to prohibit any officer from enforcing any other provision of law. The NYSRTRA also creates a private right of action. Plaintiff argues that the broad, straightforward provision of the Right to Record Acts mean what they say. People can record police. The court agrees. Where the language of a statute is clear and unambiguous, courts must give effect to its plain meaning. Citations. In interpreting a statute, we must first look to the language of the statute itself, and, if the statutory terms are unambiguous, our review generally ends and the statute is construed according to the plain meaning of its words. Citation. The Right to Record Acts allow for the recording of law enforcement activity and police activities. Defendant does not dispute that officers interacting with civilians in a police precinct are performing law enforcement or police activities. The Right to Record Acts do not carve out police precinct lobbies as places where individuals are not allowed to record, and the court declines to read that limitation into the Right to Record Acts. Citing to both Right to Record Acts, the NYPD Legal Bureau Bulletin acknowledges that the right to record police activity is codified in New York state and local law and extends to those individuals in both public places such as streets, sidewalks and parks, as well as private property such as building, lobby, workplace or an individual's own property. Defendants offer no opposition to plaintiff's argument other than to claim that under the First Amendment, and as well as the state and city right to record statutes, plaintiff will not succeed on the merits. Defendant concedes that the Right to Record Acts do not require a forum analysis, and as plaintiff avers, the Right to Record Acts go beyond the protections of the First Amendment. They protect the right to record except when someone is physically interfering with law enforcement or breaking the law. Citations. And citation noting that the statute at issue was even more protective of individual rights than the First Amendment. Defendant does not argue, nor could it, that the NYPD procedure, which is an outright ban on all recordings, falls under the limited exceptions permitted under the Right to Record Acts. Accordingly, the court finds that plaintiff is likely to succeed on his claims under the Right to Record Acts. Citywide Administrative Procedure Act. Because the court finds a substantial likelihood of success on the merits for the Right to Record Act claims, and because the court finds that the plaintiff has demonstrated irreparable harm absent the issuance of a preliminary injunction, and that the balance of the equities favours granting a preliminary injunction, the court declines to analyse plaintiff's claims under the Citywide Administrative Procedure Act. Citation. Because the court finds that plaintiff has shown a likelihood of success on the merits of its federal claim, the court declines to address plaintiff's likelihood of success on its claims under state law. I should say, make that clear, that's a citation to another case. That isn't this case, because obviously the federal claim didn't succeed here. C. Plaintiff makes a strong showing of irreparable harm. In addition to demonstrating the likelihood of success on the merits, plaintiff must also make a strong showing of irreparable harm absence the issuance of a preliminary injunction. Irreparable harm is an injury that is not remote or speculative, but actual and imminent, and for which a monetary award cannot be adequate compensation. Citation. The court finds that plaintiff has made a strong showing of irreparable harm. Plaintiff records and posts videos to educate the public on how their public officials behave and to hold police officers accountable. He states that recording and posting videos is necessary to report on law enforcement's lack of accountability and lack of transparency. I know most of us probably won't agree that that's the reasons that he does it, but hey-ho. If plaintiff were to wait until the end of a trial for a decision in his favour, he would not be able, in the meantime, to provide a window of transparency into police officers exercising their duties. Transparency in government, no less than the transparency in choosing in our government, remains a vital interest in democracy. Why sides are stupid. Sorry, it is why sides are stupid. Moreover, the prospect of the procedure being enforced has already caused plaintiff to forego recording in police precinct lobbies. Without an injunction, plaintiff faces a choice between pursuing filming the police, something that New York law unequivocally permits him to do, or being arrested because of NYPD's continued enforcement of this procedure. In light of the ongoing nature of this harm, monetary damages would not adequately compensate him for his injuries. Accordingly, this factor weighs in favour of granting the preliminary injunction. Balance of the equities and public interest weigh in plaintiff's favour. In addition to a substantial likelihood of success on the merits and a strong showing of irreparable harm, plaintiff must also show that the balance of equities tips in his favour and that granting the preliminary injunction would serve the public interest. Citation. The court must balance the competing claims of injury, consider the effect on each party of the granting or withholding of the requested relief, and pay particular regard to the public consequences in employing the extraordinary remedy of preliminary relief. Citation. As stated above, the city has made a colourable showing that privacy, security and safety concerns are implicated by recording in police precincts. Those interests, however, are not so great that they outweigh the enforcement of clear laws duly passed by elected state and city officials. In passing the right to record acts, the legislators presumably considered the privacy, security and safety concerns that might result from a broad statute, allowing the public to record law enforcement, and they found that transparency and accountability of law enforcement officials outweighed those concerns. The court finds no basis to disturb that decision. Law enforcement is part of the democratic system of government, and the public has a legitimate interest in seeing how law enforcement operates. Citation. And that's noted that the public has an interest in the responsible exercise of the discretion granted police and prosecutors. Access to information regarding public police activity is particularly important because it leads to citizen discourse on public issues. Citations. And there's another one to Liberty Freak. I know certain people say auditors have not, had any wins, but, you'll see them here being quoted in case law. Filming the police and other public officials as they perform their official duties acts as a watchdog of government activity and furthers debate on matters of public concern. Accordingly, the court finds that the balance of equities tips in plaintiff's favour and the injunction is in the public interest. Conclusion. For the reasons stated herein, plaintiff's motion for a preliminary injunction is granted. Defendant is hereby enjoined from enforcing the procedure in NYPD police precinct lobbies, except to the extent consistent with the New York State and City Right to Record Acts. Defendant is further required to remove any signs inconsistent with this order. The clerk of the court is directed to terminate ECF number 7. Right. There you go. Never mind. What is possible is that his very actions could well cause those New York state laws to be amended, because perhaps they didn't mean to allow such recording in those areas, and they might think to change it. I don't know. I think it's made it fairly clear that this is, if it needed to be made clear, but a victory for an auditor or frauditor, a victory for a frauditor in winning something in court where they profess to this right to record wherever they want to, like the driving license agency or whatever. You know, his own ruling here makes it clear that he can, there is no such right. So hopefully, Reyes will, on winning this injunction, will go back to just going to police lobbies and harassing people who can take it, as opposed to harassing members of the general public. A win is incredible. He's won on the state law grounds. I mean, I think it's. I know another channel. Went after Reyes' attorney. He went after Reyes' attorney, saying that he was in disrepute with, I think it might be New Jersey State Bar. It's only because he hadn't paid his fees, like lots of other lawyers haven't paid their fees, and he was looking at 2022, and actually in 2023 he was fully. So at the time I looked, his attorney was in good standing. I mean, just because an attorney is representing someone you don't like and you dislike doesn't mean they're a bad attorney. And if I looked him up and he was in good standing. Attorney's done his job. I mean, I don't know if he told or gave Reyes an indication that he'd be successful on First Amendment grounds, which he obviously hasn't been, which I think is good. I think, I don't think there can be much doubt that decision is probably correct under First Amendment grounds. Here you have a state legislation that has extended the rights, and who knows what's going to happen over the coming days and weeks and months in New York as to ways in which they may be able to protect their precincts. I don't know. Be interesting. Oh no, that's another state. I was thinking someone else who goes into police lobbies, but it's it's the very same as what's the name, for public safety and official misconduct in that sheriff's office last week. This right to record. Now again, I don't know the specific law in that state, and so they may have a right to record that. I don't know under the law of the state, but under the First Amendment grounds, this is made, if it needed to be made clear, that Turner v. Driver and what have you does not extend into the police lobby or the sheriff's lobby or whatever other lobby. So they might learn, which is a bit disappointing because less will then get arrested, and we do need some more to get arrested because it makes it fun. And I do apologise for the lack of arrests or the lack of my videos, because I'm not going to put videos out, just as I said, just for the sake of putting videos out. Right, it's late. Thank you all for joining me. I'm going to close it quickly. I do apologise, but my voice is going. I think it's this is one of the interesting cases to me. The ruling, the way he's won, but he's lost. And he's lost, but he's won. Right. Good night.